8 November 1994. On a late autumnal morning, the United Nations Security Council, after a fierce debate, has just adopted Resolution 955, establishing an international criminal tribunal for Rwanda. The tribunal's territorial jurisdiction will cover Rwanda and the neighbouring states, where acts of genocide and other serious violations of international humanitarian law were committed between the 1st of January and the 31st of December 1994. Its task is to try the perpetrators of the Rwandan tragedy, to punish those found guilty, and thereby to deliver a message strong enough to discourage any thought of a repetition of such heinous acts by anyone, anywhere. The international community, anxious to palliate the worst excesses of dictatorship, had already established the Nuremberg and Tokyo tribunals in the aftermath of the Second World War. Another tribunal was established in 1993 to try offenders in respect of the former Yugoslavia. The International Criminal Tribunal for Rwanda, established a year later, is therefore the fourth of its kind. On this occasion, the international community has sought to identify the causes and understand the reasons for such heinous acts, and hence to contribute towards the reconciliation of the Rwandan people. Some months earlier, on a grey April morning shrouded in mist, Rwanda awoke to an apocalyptic atmosphere. God had deserted Rwanda the day before and would not return for 100 days. 100 days that the Rwandan cataclysm lasted. Between 800,000 and 1 million people dead. The tragedy plunged the entire country into mourning, and the whole African continent was affected. Millions of Rwandans were forced into exile. Never in human memory had killing occurred on such a scale, in such a short time, and with such crude weapons. No one was spared, neither women, nor children, nor the elderly. The country of 1,000 hills was a vast burial ground. Death and devastation were everywhere. Rwanda had foundered in unspeakable horror. After establishing the tribunal, the Security Council decided to locate it in Arusha. A small town at the foot of Mount Meru in northwest Tanzania, not far from Mount Kilimanjaro, famous for its eternal snows. Arusha has approximately 200,000 inhabitants and is better known for its mild climate and easy access routes for safaris to the Serengeti, Manyara, and Ngorongoro parks than for its communications infrastructure. The Office of the Prosecutor was established in Kigali, the capital of Rwanda.
Good afternoon. How are you?
In order to facilitate investigations in general and of the sites of massacres in particular, as well as to facilitate the search for witnesses. The former headquarters of the United Nations Assistance Mission in Rwanda, known as UNAMIR, near the stadium and the airport, provided premises to house that office.
Le staff du procureur travaille.
The prosecutor's staff work in Kigali in close cooperation with the people of the area, and in any case with those in the field. We are unable to do this, which seems to me to be a significant difference in our capacity and efficiency.
There is definitely inequality of treatment as regards the resources at the disposal of the defense and those provided to the office of the prosecutor. Here we are in my office. You will see. The computer is totally obsolete. Access to the internet is a matter of luck with this one. Yet they have an extraordinary, extremely interesting data bank called TRIM, by which any information can be found. We used to have access to it, but now we don't.
La défense doit se rendre compte d'une chose.
The defense should realize one thing. A lawyer is, first and foremost, an independent agent. We do not want defense lawyers to be civil servants like the jurists in the office of the prosecutor. And when we talk about equality of arms, the idea is not to say, yes, there is a budget, let us say, of I'm advancing a figure of $25 million for the office of the prosecutor, so there should be $25 million for the defense. No, that's not what is meant by equality of arms. Equality of arms is provided for in the legal and statutory instruments to ensure that the defense plays its role fully and with full regard for the rights of the accused.
The tribunal's beginning in 1996 was not easy. Arusha lacked the adequate infrastructure to host such an institution and all its requirements. Everything had to be built up from scratch, including satellite communication links, offices for the court officials, as well as the courtrooms where the trials would be held.
Well, I must say I received a big shock too. I am from South Africa, so the then registrar, Mr. Adeda, in the company of the then prosecutor, Judge Richard Goldstone, called me and said, well, since I'm the closest, can I come over to hear the first confirmation proceedings of the first indictment. And I was really shocked. There was no building, there was nothing, there was no court. We sat in the hotel room. We worked with the typewriter of the manager of the hotel, with the typist who couldn't type. So at a borrowed table and borrowed chairs in an office, and with a quickly wooden carved stamp, I signed and issued the first indictment.
Three distinct and complementary organs constitute the tribunal. The chambers, including the appeals chamber, which is common to the ICTR and the ICTY, and three trial chambers. The office of the prosecutor, headed by the prosecutor, who is also common to the two ad hoc tribunals, and the registry, headed by the registrar, who is in charge of the administrative, financial and personnel matters. The registrar is also responsible for providing judicial support to the trial chambers and the parties. Within the registry, one very important section deals with witness protection and is responsible, inter alia, for bringing witnesses to Arusha and providing them with the necessary security and psychological support to enable them to testify before the trial chambers.
A certain measure of protection must be given to these witnesses. It is necessary to ensure that after their testimony, neither defense nor prosecution witnesses are either harassed or persecuted by anybody whatsoever.
The reality of the tribunal was made clear to the first accused persons to make their initial appearances before it. There were three in the dock. Their initial appearance took place in a room provided by the Arusha International Conference Centre, which hosts the tribunal. It was a cramped room not intended for such purposes, that had been hastily adapted.
The trial chamber 1 of the International Criminal Tribunal for Rwanda, composed of Judge Lete Kama, presiding judge, Judge Leonard Aspigren, and Judge Nemaneth Demfile, is now in session.
Do you plead guilty to crime against humanity, murder? Do you plead guilty or not guilty? The proceedings are adjourned.
George Rutaganda, Clément Kaishema, and Obed Ruzindana entered pleas of not guilty in the presence of their counsel, duly assigned by the registrar. Those three accused persons were also the first to be detained at the detention unit, which was then still under construction. Its 56 cells were completed soon afterwards and now house nearly 60 detainees.
Le peuple l'acclamait beaucoup, ce ne sont pas les pharisiens qu'on a acclamé. C'est pour cela que le Christ pleure sur Jérusalem.
At visiting times, the accused and their assigned counsel consult and prepare their cases in the visiting rooms. The unit is the first of its kind to be built and managed by the United Nations. It's under the authority of a commander responsible for ensuring discipline and the observance of the rules governing a prison establishment. Several high-ranking officials of the former Rwandan regime, including civilians, military officers, and clergymen, are among the detainees. On 9th of January 1997, the trial of the former mayor of Taba, Jean-Paul Akayesu, opened in the sole courtroom available at that time. The accused appeared before the bench of Trial Chamber 1, presided over by Judge Leiti Kama of Senegal, assisted by Judges Nvanathan Pillay of South Africa and Lennart Aspergren of Sweden. Jean-Paul Akayesu was subsequently found guilty of genocide and sentenced to life imprisonment, the maximum sentence that the tribunal can impose. The verdict, the first to be delivered in matters of genocide by an international court, was upheld in due course by the appeals chamber. In their judgment, Judge Leiti Kama and his colleagues called genocide the crime of crimes. They went further and extended the definition of genocide to include sexual assault and rape, henceforth considered constitutive elements of the crime of genocide.
It's the first time in history that an international court delivered a decision on genocide since the Genocide Convention was passed in 1949. And the other feature about that case is that for the very first time, once again, rape was found to constitute the crime of genocide, because in that case there was evidence that Tutsi women were being targeted with the intention of causing the destruction of the Tutsi group as a whole. Akayesu did not personally commit any acts of killings or rape or other atrocities. So that's the other very important feature, that even though he personally didn't commit the acts, he was held responsible because he's a superior officer.